Reports at this time, Mr. Dixon?
I do have Mr. William Scheinoff from the France Law Group online, and he has a brief presentation regarding the vaping class action suits. And I don't know when you would like that to appear in the agenda, but it can fit under my report section if that's...
If the board so approves or wishes, we can just go ahead and allow him to report now.
Can you hear me all now?
Yes, we can.
All right. Well, I'll try to make this short. I thank you all very much for your time. I appreciate it. I wanted to let you know what's going on in your state right now with school districts getting involved in a national litigation against a vaping company, Juul Labs Inc., and Ultra, which many of you may know as Philip Morris. My firm is currently working with Lewis Tomlinson in representing school districts throughout Tennessee. There are already a number of school districts in the state that have joined, and a number that I'm going to be presenting to in the next month to join. So what this case is, this is not a class action. This is what's called a mass action. So each school district will have their own case, but all of the cases are going to be joined together and venued in one courtroom in San Francisco. And so what this case is all about is the fact that these companies went and intentionally marketed their products to children. And now that we have a lot of children that are using the product, schools are being left into an unfortunate situation of trying to figure out the best way to deal with it. And this case is about providing your district the resources to be able to battle this issue. And so what we're looking to do there's multiple components to it of what the monetary aspect of it is. So if you look at it as an overarching issue, we're looking at items to help support deterrence of vaping on your campuses, support to the children who are currently dealing with the addiction to this product, and then educating children about why they should not be using this product. So we have experts in place who have provided us the best way to deal with this. And so in order for us to deter the children on vaping on campus, they've advised us that we should get your districts the resources to install vape detectors in bathrooms, because a lot of vaping is going on in your bathrooms. The other thing that we're looking at is they told us to create a 5 to 10 year funding model to be able to provide your district with the money to be able to hire additional staff for supervision. So kids understand that they can't go and do vaping in the hallways or even in the classrooms or in the bathrooms, because there are going to be that additional staff looking out for this. And another aspect is the support. So what this product is, this product has 10 times the amount of nicotine than a cigarette, so it's highly addictive. And when you're dealing with children with nicotine addiction, there comes social and emotional issues. So what this case is doing also is providing districts with the money to be able to hire additional counselors to be able to help these kids deal with this issue. And then finally, and what I believe is the most important, is funding for education. Unfortunately, with the way this product was marketed, there is a misconception that this product is safe, that there is no harm to the product, and that a lot of kids do not understand that, number one, that there's nicotine in it and there's chemicals in it, and how harmful they are. So with education, as we've seen with DARE, it helps bring down the numbers of kids using it. And the big aspect of this case is this product was created in a way that it can be done in secret. It's not like a cigarette where you can smell it, it's going to leave a smell somewhere or on you. It can literally be done in a classroom with the teacher's back turned, and they will never notice. So what we are looking at is not only, in order to support our case, are we looking at your school's numbers of discipline issues related to vaping, but we also go and look at your county health information regarding children under 18 that are vaping. And what I can tell you is, through doing my research in your state, is that the lowest number, because what the health departments have been doing is they go and do studies on asking kids under the age of 18, in the last 30 days, how many of you have you vaped or tried vaping? The lowest number I've seen in the state of Tennessee is 40% that responded. So that's an extremely high number for kids that should not have access to a product. And unfortunately, this is an issue that's not going away. And so with this case, it will provide your school with the financial resources to be able to deal with this in the future without having to take money out of your general fund. In addition to being a case about bringing in financial resources, it's also a case about creating change. So what we're also doing in this case is asking for injunctive relief, which is asking the court for an order to prohibit conduct. So just as what was done 30 years ago in the tobacco litigation, what we're asking this court is to make sure that this company is the same regulations that are on these tobacco companies is put on these companies as well, so they cannot go and intentionally market their product to children. So we do not keep seeing and deal with the issue that we're seeing today. In addition, we're also asking for the court to prohibit the sale of the flavored pods that really brought a lot of kids to the product because they are extremely harmful, and the financial benefit to the company is completely outweighed by the harm to the community. And so that's what this case is about. To explain to you two main points before I finish off, when I'm normally doing this presentation, this is the two main questions I end up getting from board members is the time consumption to be involved by your staff to be involved with this case. So because this is a mass litigation, there's not going to be depositions of your administrators or staff. All that will need to be done for your district to participate is answer a 30-question questionnaire, which is made up of yes or no questions. So it will not take your staff much time. It would probably take them about an hour or two to do that. The other question that's asked is the cost to be involved. There is no cost to be involved. We work on this case on a contingency fee basis. So that means that if there is no financial resolution to the district that is achieved from this case, then the district owes no money. They don't owe my firm fees. They don't have to reimburse us the cost that we put forward to the case. It can only bring in money to the district. It cannot take out any money. In addition, normally our fee in plaintiff litigation would be 40%, but we've reduced it to 20% if the case resolves within the first 6 months of your board joining, and then it increases to 25% thereafter, and it will never exceed that. And as I said, we're partnered with Chris McCarty with Lewis Amundsen in working on this case. Chris is going to be assisting us with this for our districts, and he will not be billing the districts for his work on the case as well. His firm is being compensated through the case as well through our fees. So besides that, I wanted to thank you very much for the time. And I'm not sure if there was any questions, but I want to provide that opportunity.
Was there any time frame as far as what you can guess as to when this thing kicks off from start to finish? Are you thinking there's going to be some sort of settlement offer early on? Do you think this will go all the way through?
So this case, this judge is a great judge. He's taken this case very seriously. He does not want to see this case turn into the 10 years of tobacco litigation that occurred 30 years ago. We actually have a trial date set for February 2022 in this case. So if there is going to be a resolution, I would say that it's going to be late fall, winter of this year. And if not, then we're going to be going to trial with our cases, and with that first round of trial, that might create the push for resolution. So I don't see this being a drawn out case, but what's going to be important though is that if a district does want to join, that we make sure that we give ourselves enough time to get all the information that we need necessary in order to determine what a proper resolution would be for your school.
Thank you. One additional question, at least for me, is time frame for our involvement. You mentioned there's different fee structures or percentages of the winnings that your firm would get on our behalf. What's the ideal time frame you'd be looking at for this board to make a decision, yes or no, to proceed? I know this is new information coming to me. It's new information for the board. If they choose for example, not to act this evening, what's the time frame best case scenario?
So we're working with our experts right now on all of our district's cases. I can tell you that right now we're around 13 school districts in Tennessee that have joined or are going to be joining within the next week. So the ideal time frame is for your district to approve joining either this month or the next month. So we can give our experts enough time and be able to consult with your administration to make sure that when there is a resolution, potentially in the fall or the winter, that we have that enough time to be able to do that work.
Okay. What about countersuit? What if you got sued by the companies countersuing for damages? Would you indemnify or hold the school district harmless in that event?
Are you asking if they countersue a school district for suing them?
Right. If they
Yeah.
countersue for damages against this.
Correct. So yes, we do indemnify the district. I can tell you I've already filed 250 lawsuits in this case for school districts all over the country, and it's been going on for 2 years. They haven't filed one countersuit because they wouldn't have grounds to. But if that does happen, yes, we would defend the district, and we would make sure that the district's hold harmless.
Can you send us some written documentation of everything that you summarized so we can
I've
look at it?
I've got the sample agreement that I will share with you, and that's why I asked about the time frame. If the board wants to look this over and discuss it, I was just making sure this evening that we didn't have to act right away. There'd be time
I would
to
not
make a
recommend
decision.
acting immediately. I think we need to look at
I think if it's the board's wishes, I would like to table this until next month's meeting for Mr. Phillips to do some investigation, some board members to do some investigation, and make sure we're not jumping into something that we would regret in the future. I disagree with the vaping, of course. It's not healthy for anybody. But with the board's acceptance, I would like to table until April.
William, if the board has any questions, they send up through me or through Mr. Phillips. Can I get it? Is your email the best way to get a hold of you and then send those up to you?
Yes, and also what I can let you know, I'm not quite sure what the relationship is with Mr. McCarty in your school, but it has been reviewed by his firm, these agreements, and these are the agreements that the districts across the state are going to be using. So to give you that extra assurance, it has been reviewed by their office.
Okay, thank you. That does help.
Thank you. So, Mr. Phillips, if you could look into this for us.
yes, you say you've got material we need.
I've got William's sample contract language I can send over to you, and that spells out the percentages he discussed and what the suit is.
And that would be the contract we would sign, essentially.
Correct.
All right, yes, we need to look at that. And
Okay.
Thank you very much.
Be aware of whatever we.
You can return the host back to us, please.
Thank you all for your time.
Thank you.
Copy of that also.
We can, if you
I think I'd like to see.
can we do that?
Yeah, I'd like to.
I've got it in my email. I can email it this evening.
Did he name the other 13 districts that had joined with him
I've not seen that.
in your paper?
I have not seen that name, but Mr. McCarty probably has that. I can get that.
Okay.